Hello, everyone, and welcome to Uncivil Law. And for today's stream, we turn our attention to a United States Supreme Court case which asks, to my mind, a somewhat strange question. Can failure to act be violence? I would think the answer to this question is no. I would think violence would require you doing something. But that's the question. Can failure to act be violence? So let me give you the facts of the case and the exact question presented, so that we can discuss this in a little bit more intelligence. This is the case of Delligatti versus United States, Salvatore Delligatti versus United States. And the facts of the case are thus: Salvatore Delligatti, an associate of the Genovese Crime Family, Hala New York mob, was convicted of various charges, including attempted murder in aid of racketeering under the Violent Crimes in Aid of Racketeering Statute, and possession of a firearm in furtherance of a crime of violence. Delligatti had organized a plot to murder Joseph Bonelli, a neighborhood bully who had been stealing from a local gas station owner and was suspected of cooperating against bookies associated with the Genovese Crime Family. Delligatti paid another man to coordinate the murder with gang members, providing them with a gun and a car. The murder attempts were ultimately unsuccessful due to the presence of potential witnesses and the arrest of the would-be murderers by law enforcement. So the man put out a hit. He put out a hit as a mob member. And it's like, go kill this guy. And then his stooge associates bungled it up. All right. On appeal, Delligatti argues that the firearms conviction should be vacated, which was the use of a firearm in furtherance of a crime of violence. So that should be vacated because the predicate offense, including the attempted murder charge, were not crimes of violence under the law. Attempted murder is not a crime of violence. Okay. All right. The U.S. Court of Appeals for the Second Circuit affirmed to the lower court, concluding that attempted murder in aid of racketeering qualifies as a crime of violence, as it necessarily involves the attempted use of physical force. I mean, I would think so. If you're going to murder somebody, probably going to be some force involved somewhere in that equation. So, I mean, I would think that the attempted murder qualifies as a crime of violence, but okay. The question presented, however, is, does a crime that requires proof of bodily injury or death, but can be committed by failure to take action, have as an element the attempted use or threatened use of force, which seems like a very strange way of phrasing the question to me. That's a very strange way of phrasing the question. Because it's attempted murder, right? And the murder is the crime of violence, and you attempted it, so that's like committing the murder. It's like attempted murder. So murder's violent, so attempted murder is violent. So I'm not sure how it's failure to take action in this scenario, but that is what the Supreme Court apparently is going with, or that's the question presented. All right, so we're going to listen to this argument and see if it makes more sense as we go along. But my opinion before we start is twofold. First of all, you need to have a crime of violence. It needs to be action, but any action that's violent or restrictive or forceful will probably be sufficient. So failure to act, no. Attempt, yeah. Attempt is the use of force. You tried really, really hard. So, you failed, but you tried. A for effort. So close enough for me. But this is about failure to act. So, okay, we're going to watch this and see if it makes more sense.
Next in case 20.
All right, let me put on the audio the other way so that you can hear it.
825, Delligatti versus United States.
Mr. Chief Justice, and may it please the court. Using physical force against another requires taking some step to bring force into contact with the victim.
Okay.
That can happen directly, as with a kick or punch, or indirectly, such as giving a gentle push to someone teetering on the edge of a cliff.
I wouldn't view that as indirect. That still seems direct to me. in this scenario, it doesn't require much force because they're already teetering on the edge of a cliff. So it's true that it's not much force in the grand comparison, but that's not indirect. That's still direct. I'm still pushing you. So I'm not sure how that's indirect, but okay.
But it does not involve an offense that can be committed by pure omission, such as failing to render aid to someone suffering from a natural disorder.
I agree.
The government's attempt to reverse engineer the use of force from the presence of injury is contrary to logic and plain meaning. It also runs counter to this court's instructions that use means active employment, that physical force is violent force, and that against another means making contact with another.
Yeah.
The government's appeal to practical consequences, in addition to being irrelevant to interpreting the statute's text, is similarly unpersuasive. At the time the Elements Clause was adopted, all or nearly all of the statutes identified by the government would have satisfied the Residual Clause. And per the government's hedging here, many will satisfy the Elements Clause too, regardless of whether crimes of omission are excluded. A failure to counteract harm may be morally and legally culpable, and it may merit severe punishment, but it does not categorically involve the use of violent physical force against another. I would welcome the court's questions.
Yeah, I mean, I'm sort of on board with this. Failure to act can be criminal in certain circumstances, such as you have a duty, or you yourself have created the harm in the first place. So you basically have a duty to mitigate your own harm. So either you have a duty because they're your child, because you've taken on the duty by contract, you have created the harm, and so you have a duty to undo the harm or mitigate the harm that you yourself created in the first place. But failure to act is not violence. The creation of the problem might have been violence, but not necessarily the failure to act. So, for example, just as a somewhat trivial example, if I push you into a lake of water, and it would be helpful if I know you can't swim. That would be really helpful in this scenario. So let's assume I do. Let's assume that I do. Let's assume that I push you into a body of water and I know you can't swim. And so you're flailing around, okay? At this point, I do have a duty because I'm the one who created the problem. Now, if I fail to act to rescue you, that itself wasn't the act of violence. But the act of violence was me pushing you into the water in the first place. So, yeah, I'm not sure 100% what we're talking about.
So in your thinking, if you poison someone and thereby cause the death of that person, that is, in your argument, under your argument, treated differently from withholding critical, say, heart medicine when someone is in the process of having a heart attack.
Right. I mean, at this point, I am using poison as the force, but I'm still the one that's poisoning you. Right? I'm giving you the poison. So the poison is doing my dirty work, but I'm still the one acting by giving you the poison. It seems like I'm acting versus me not giving you the heart medicine. Okay.
That's correct, Your Honor. So this court has described poison as having forceful physical properties that you would have put into contact with the victim by putting it in their drink. That's a very different situation than someone who potentially through natural causes slips into distress and you don't take any action to put them into contact with any force, and there may not be any force involved if, for instance, it's a congenital disorder.
Right.
So there's no force at all and you wouldn't have used that force actively.
I agree.
I'm sorry, I don't know. You almost seem to be talking proximate cause. There's no force.
I'm almost talking actual cause at this point because I'm not doing a thing. I'm even talking about action. I'm not even talking about causality. I'm not even sure we're back to step one of did I do a thing? I'm not even sure we're on causality, but okay.
In the poison itself and what you did, the force is in the nature of the substance that goes through the person's body. Similarly, there's no violent force in a gentle push of a 90-year-old down the stairs. You could probably do it with a finger. So there's no violent force there.
Bullshit. Bullshit, that's not violent force. Bullshit is what I say. It doesn't take much force. It doesn't take a lot force, but I'm using force and it's violent. Bullshit, that's not violent force. What are you talking about?
There. What you seem to be saying is if I have a duty to act and I choose not to, I'm not responsible for the force that I let work on this human being. That's your position, correct?
No, Your Honor. So in both the poisoning example and giving a gentle push to someone who falls down the stairs or off of a cliff, you are not directly applying violent physical force. It's a gentle touch, or you're just letting the molecules of the poison fall from your hand. But there is still an application of violent physical force when they hit the ground at high speed.
How is that not violent force? How is the gentle touch not violent force? I mean, I agree it's not much force, but in the scenario that we've set up, like I basically am aware that this amount of force will create this problem. So it's not even like a mistake issue, which somehow like maybe that would somehow absolve me, right? We're talking about a 90-year-old on the stairs. It's reasonable for me to know, or I should know, or probably do know, that it doesn't take a whole lot of force to push that 90-year-old down the stairs. So we're not even in some sort of mistake, or this is some weakened person that I don't know about, or we're not even in like an eggshell skull kind of scenario. Like I take the victim as we find them. It's like, I know what this victim is, and I'm using the amount of force that's required to create the harm, but I'm doing it with that intent in mind. It's like, I know that I'm doing that because I know they're an 80-year-old person and frail and walking down the stairs. How is that not violent force in that scenario? I am so confused by this hypothetical.
I would tell someone who's freezing in the snow that there's an application of winter conditions to their body to kill them.
Sure. In that instance, again, you might describe the elements as involving violent physical force, which perhaps you could describe as using indirectly if, for instance, you throw them out into the snow. But that's
which, again, in that situation, I'm not even sure I would describe necessarily as indirectly, because I was the one that threw them out into the snow, which sounds a lot like the violent force. This is a very odd scenario to me, because this is a very odd thing, because normally in law, we're like, oh, you know, you're kind of responsible for anything that's at least reasonably foreseeable at a bare minimum. So it's like, if I throw you out into the cold, right, and then the snow gets you, that's kind of murder, man. So, yeah, I mean, I don't understand. I'm confused.
It's a very different situation than a pure omission where someone, let's say, has an allergic reaction.
It's not a pure omission. It's an obligation to act.
Sure.
I mean, I could be in a restaurant watching someone die, but I have no obligation, even if I know the Heimlich maneuver to do it. However, if it's a child and my child, I have an obligation to try to save them.
That's correct, and it is a serious
offense. So I'm letting nature use its force to kill that child.
So there's no dispute that it is criminally culpable behavior and can be punished severely. But the question is there violent force being applied to the victim, and have you actively employed that force? And in a situation where, for instance, you just don't provide medicine or nutrition to someone and they slowly expire, there is no violent physical force of any sort. It's not like hitting the ground at high speed. And moreover, you haven't taken any step to actively employ any force.
I guess I'm not sure I get that. In the poison case, you're agreeing that it's not my putting the poison into the drink that's violent physical force. Rather, it's the way the poison acts on the body.
Right.
And in the withholding of medication situation, it's similarly the way the disease acts against the body. And you are enabling that disease to run.
Right. So
again, I'm not really even sure I concede the hypothetical, to be honest, because is putting poison in someone's drink the act of violence? I mean, I would say yes, it's the act of violence, because, and it's force. It's force. It's delayed force. It's a spring trap, if you like. It's a gun that it's a gun or a bomb that hasn't gone off yet, but you know, there's still force and intent to use that force and desire to use that force and desire that the force will come to pass, and I'm the one actively doing it. So I'm not sure that I concede the point that me putting the poison isn't itself the act of violence. Me putting the poison into the glass is the act of violence. You know, if I put it into the glass with the intent that you drink it, then the very moment I put the poison into the glass, that's attempted murder. The crime of attempted murder is complete. We're not sure if it's murder yet, because we're not sure if you're going to drink it or not, but it's attempted murder. You know, I'm trying really, really hard, and so I'm using force. I don't, okay, I'm not even sure I can see the hypothetical.
I think this court has analogized poison to sort of like a little explosive device that detonates when you swallow it.
Right.
I don't think the same is true, for instance, to just the.
I have no problem analogizing poison to a bomb. They're both waiting to go off. Sure, that makes sense to me. I'm on board with that. That's fine. But once I plant the bomb, whether it's actually a bomb or poison, seems like the violence is there, man. Yeah.
Absence of chemical inputs as necessary to keep your cells going. That's not analogous to violent physical force. And even in the poisoning example, you are still taking some step to bring the person into contact with that poison, without which they wouldn't have the force applied to them at all, even indirectly.
So if I take a hostage and then just let the hostage starve, which side of the line does that fall on?
What about this? What about this am I missing? This is the thing that I'm like, what am I not getting? Because these questions seem like really dumb, or the answers seem like incredibly obvious. Hey, if I take a hostage and, you know, they die from starvation, is it still violence? I don't know. Did you take the hostage? Sounds kind of like violence to me. What are we talking about? I don't know.
For you.
So putting aside that would probably be a threat or, you know, attempted
physical
use of force.
Just
sure.
Physical force.
So let's say there was someone sleeping in a room and you lock them in the room and then they slowly expire. From our perspective, that would not involve application of violent physical force. And you could say you used the locks, but you haven't actually used force against them.
Well, what do you do with the fact that Stokeling is...
Again, I don't concede the example. I don't concede the example. If I lock you into a room, I am using force to prevent you from leaving the room. Namely, the locks. What are we talking about? I don't... Okay.
Especially seems to measure force not from the front end, like force applied, but from the back end on what does the force, what is its result. It seems to me that for murder, necessarily the result was pretty extreme.
So, respectfully, I don't think Stokeling takes that position. In fact, the whole discussion in Stokeling was how much force do you need to apply? What's the amount of force to overcome resistance? Which, again, the court wasn't focused on whether the person was injured or not. It was, can you do it just sort of by gently grabbing it, or does it need to be more
But the
vigorous?
measure of the force, if you're prying someone's fingers off of a purse, I mean,
Right.
the measure of force, I wouldn't describe that as severe or aggressive.
And that was the back and forth, but everyone was focused on that same question. So they were still focused on how much force was involved. You look also, for instance, at Castleman. So Castleman gives the example of a squeeze of an arm that causes a bruise, which the court said would count as common law force for purposes of domestic violence, but would not count as violent force for generic purposes, which shows that even the direct application of enough force that sometimes causes an injury, a bruise, is not enough because it's still not a high enough degree of force.
Mr. Kadam, you know, our intuition is that often omissions are just as bad as acts, and they're sometimes hard to distinguish, and certainly it can be murder when there's a pre-existing duty of care that you then omit to fulfill. All right. But there are some places where they have gone well beyond that common law rule and imposed a duty of care even for the Good Samaritan. So,
Is there places that have imposed a duty of care for the Good Samaritan?
let's take a hypothetical. someone comes across the streets, sees that the manhole cover's open, doesn't rescue the little old lady who steps into it because this person has animus toward little old ladies. Now, extreme hypothetical. Justice Breyer might be proud. That would be murder in a state with a Good Samaritan statute.
What state? And it really? And is it? And are we sure? I don't know, man.
Physical force, I guess the gravity's, what more powerful force in the universe is there than that? Would that, in your view, fall within the government's understanding of what would qualify as the application of violent force?
It would have to. The government's view essentially is anytime you have a bad result, you know that there must have been violent physical force, which means that not only would the death or other injury in your example be violent physical force, it would also be involved in literally every death since the beginning of time, because in every death, something bad happens because you either are injured or run out of the cellular inputs necessary to sustain life.
And if I might just ask a slightly different question. This is one that, I don't know of any more powerful force in the universe than gravity. But I wonder whether
the strong force?
This statute is divisible between acts and omissions. And that isn't something either side explored. I know it won't help your client. Okay. But perhaps I welcome your thoughts on whether you think this statute is in fact divisible.
So this statute is not. We have opinions from the Court of Appeals, the New York's highest court, saying that the statute can be committed either by affirmative acts or by omissions, including pure omissions. So we have the Wong case where there were two caregivers, one of whom shook the child, the other of whom failed to render aid.
Yes, and their duty of care cases, and classic common law duty of care cases. So you have to prove a duty and then the failure to fulfill it.
That's right.
Very different than killing somebody or ordering a hit on somebody by act. I mean, giving them a pistol in a brown paper bag is a little different.
It is. Presumably, if the government thought that this statute was divisible, they would have argued it. But I think your question really highlights an important point, which is it just so happens that this murder statute can be satisfied either by acts or omissions. But the government's argument would have to be the same even if New York had a murder by omission statute that could only be satisfied by a pure omission in which there was no actus reus whatsoever other than just having a duty that you failed to satisfy. And the government's argument would have to be in every single instance of that murder by omission statute, violent physical force was involved.
And I take it your argument is that when we look at the federal statute and its definition of crime of violence, that really what is at issue here is the conduct of the defendant.
That's
that
correct.
It's not whether force is operating in the universe to achieve a certain result, but the plain text here seems to suggest that we're looking for use, attempted use, or threatened use of physical force. And that, at least the common sense view of that, is that it's the defendant acting to use, threaten to use, or attempting to use. Is that the thrust of your argument?
It is, Your Honor, and I would emphasize there are lots of criminal statutes, including in 924, in fact, even in 924C, that focus on outcomes. So subsection C5b applies a heightened penalty if death results. The elements clause, by contrast, is, as you've described it, focused on the method, a particular way of committing an offense that Congress associated with armed career criminal behavior.
And I take the point that ordinary understandings of what it means to use violent force might not cover omissions, but so too it wouldn't cover poison. And we have said that it does cover poison. So
again, I have no particular problem with it covering poison, because even in a poison, you're doing something. Namely, you're putting the poison in the glass, right? I mean, that's still the act. You're still performing the act. And the poison is violence. And so you're performing an act of violence. So I have no particular problem saying that poison is violence. That's fine by me. I'm not quite sure how we still get to omissions though, because I'm still poisoning you. So I'm confused by that.
We're not really operating in a world in which it's completely sort of ordinary Joe understandings of the phrase.
So respectfully, Your Honor, I agree poison is sort of the outer limit, but I do think the court was making a point there, which is that in response to the defendant's argument in Castleman that essentially you had to apply the force directly in order for it to count, the court said, no, if you put poison in tea, it's very much like pulling the trigger of a gun. It's a gentle pull of the trigger. That's not the violent force. The violent force is later when the bullet makes impact. But still, in both of those instances, you're still doing something to bring the victim into contact with.
I'm not sure I necessarily agree with that. I have no particular problem saying that the pulling of the trigger is the act of violence and is the violent force. It's the violent force of pulling the trigger. You know, the trigger pulls the trigger pulls the firing pin. The firing pin hits the primer. Primer causes the powder to burn. The burning causes some pressure. The pressure causes the bullet to hit to go through the barrel. The barrel enters the bullet enters the body, right? So I mean, it's just like, I mean, you know, it's a bit maybe it's slightly Rube Goldberg, but like it's like I have no particular problem saying that the act of violence was the pulling the trigger. That was the act of violence. I have no particular saying that's the use of force. That's an act of force upon the person. Because I'm doing something that is creating a chain of causation that is going to cause force to you, right? This is very odd to me, because I mean, I understand that there's eventually a proximate cause problem somewhere along the line, but you know, maybe in an as applied, we'd have a really tough time, you know, saying where the proximate cause eventually pans out. But with like me shooting you and me putting the poison in the tea, I'm not really seeing the proximate cause problem. You know, there might be a lot of steps, but like those steps are all very readily foreseeable and somewhat direct consequences of your actions. So I have no problem saying that me, you know, pulling out the dropper and putting the drops in your tea is the act of force. That's the act of force. That's the force of violence upon you. That's fine. We're just tracing back, you know, the ultimate death back to its ultimate cause and saying, well, that was the act of violence. I'm like, that's fine by me. It's like, because you know, the alternative is I excuse myself because it wasn't really me applying the violence, right? It's like, oh, it wasn't me that did the violence. It was the bullet that did the violence. Bullshit. So like, I'm happy. I'm perfectly happy saying that the 3-pound pull the trigger is the use of violent force. I'm perfectly happy with that. And in any event, it's still an action. So I'm still not sure what we're talking about. Maybe we have a different view of what it means to perform an action versus an omission. I don't know what we're talking about. I'm very confused by this.
That force, which may be wholly absent in the case of a pure omission.
You're still using something. You're still using actively.
How about if instead of putting poison in, I knew that there was something in the refrigerator which had gone very
MLS,
bad,
that's some bullshit. No. You've drawn the wrong conclusion as far as I'm concerned, MLS. You say, I like the argument. So if I pull the thing and the other thing fails to fire, that's not attempted murder. Yes, it is. Yes, it is. If I pull the trigger and the gun doesn't go boom, I still tried, man. I still tried, right? I still used the force. I still used force. I gave it the college try, man. Close enough. Hands, shoes, and hand grenades. So yeah, I'm you know, the bullet doesn't go bang. I still used violent force. I really tried. I tried really, really hard. Close enough, man. Close enough. Yeah.
toxic. And I said to my worst enemy, why don't you eat that cake in the refrigerator? Where does that fall on which side of the line?
That sounds a lot like the food in the fridge is poison, and you're just tricking them into consuming it.
Correct, and so
it would count as use of violent physical
even
force.
Though now you haven't done anything, really.
Well, respectfully, you have taken some step to bring them into contact with it, without which, if you hadn't taken that step, they wouldn't consume what was in the fridge.
Well, I mean, in any of these cases, including in the supposedly pure omission cases, we can find some step. I mean, when you're withholding medicine from the ailing person.
Whoa. What exactly do we mean by withholding medicine is going to be really key here. What do we mean exactly by withholding medicine? By withholding medicine, do I mean that I'm preventing them from getting access to the medicine? Do I mean that I'm blocking them? Do I mean that I'm physically restraining them? Do I mean that I'm hiding it? Do I mean that I have in some way taken some, dare I say, act that's preventing them from getting to the medicine? If that's the case, then fine, I'm still taking some act. But if it's merely, oh my God, I'm having a heart attack, my pills are right over there, and I point at you and be like, lol, then no. The pills are exactly where you left them. The pills would cure your heart attack. You're having a heart attack. The pills are right over there exactly where you left them. You need them right now, and I just point at you and be like, lol. Then no, I haven't done inaction. What is the distinction that we're having a tough time with? What are we having a tough time slicing here?
Probably there's some step that you've taken that prevents the ailing person from getting that medicine herself, or there's some step that you've taken to put yourself in a position of duty to that person. I mean, there's always something that we can look to. If you're going so far as to say that my telling the person to eat the cake in the refrigerator is an action.
So I think you have to ask yourself, too.
I think it is an action. Am I bizarre for thinking it's an action? Am I bizarre for thinking that's an action? Because Kagan's over here like, oh my God, I can't believe you would agree to this bizarre hypothetical. And I'm over here like, what bizarre hypothetical? Okay, so in this hypothetical, I know the cake is poisonous. That was her premise. And I'm like, hey, go eat the cake. And you're like, okay. And then you eat the cake and you die. And she's like, oh my God, I can't believe you merely saying the thing would be an act. I'm like, why not? Why can't you believe that me saying the thing would be an act? If you can prove that I did it with the knowledge that it was poisonous, and you can prove that I did it, sounds like it could be a problem for me. So she treats it like some bizarre hypothetical, and I'm over here like, I don't know, man. I don't think it's that bizarre hypothetical. I think I'm okay with that. That works for me.
Two questions. One, is there even violent physical force involved? In the instance in which someone expires because they don't have the right medication, usually you would not describe that as involving violent physical force. So if a septuagenarian slips into a coma and then doesn't eat and as a result dies, no one is going to describe that death as involving violent physical force.
Right.
So the question is, would you describe it as involving violent physical force because there was someone who was supposed to be there feeding the nutrition tube but failed to do so?
And is that
No, I wouldn't describe that as violent physical force. No, I wouldn't describe that as violent physical force. They're not doing a thing, but I wouldn't describe it as violence. I would describe it as murder because they're failing to act with a duty act, but I wouldn't describe that as violence because I'm not doing anything, which could itself be the problem, but I don't think it's violence. So I'm gonna go with no. If I have a duty to you and I don't do the thing, I could be responsible for the failure to do the thing, but I'm still back to it's not violence. So I'm pretty comfortable with this delineation.
That because the context is violent physical force, because we're in a statute that relates to firearms, that Congress clearly was trying to get at a certain category of person.
That's correct.
The person who is of the type that they would engage in these kinds of crimes that present risks of violence in this way. I thought that was the sort of context. So all of these hypotheticals about inaction, even though there might be a step or not a step, setting that aside, the point is they're not even in the realm of the kind of thing this statute was about.
That's right. We're defining a felony crime of violence, and Congress had a very specific theory.
Picking up on that, would you argue that your client is not the kind of armed career criminal that Congress was trying to get at when they enacted this statute?
We would not argue that, Your Honor. We're focused here on the type of offense, and that's because the Elements Clause requires an assessment of the elements of the offense and whether violent physical force is present in all instances.
Well, the question is whether your client was convicted of a crime of violence, right?
That's correct.
And these are fascinating legal arguments, but some of the people who have come here to hear this case may not know much about the facts of the case. So what was the offense for which your client was convicted?
Hiring someone in order to commit a murder.
And that, in your submission, is not a crime of violence?
It does not have as an element the use of violent physical force.
And that
Uncivil is confused. Hiring someone to commit a murder doesn't have an element of physical force. Why not? It's like standard agency law that, the principal is responsible for the agent. So I've now outsourced it to somebody else. But I can't get to the principle that I'm not responsible. I hired you specifically for this purpose, to commit the murder. Hiring to commit a murder isn't an act of violence, or isn't an act of violent force. It seems like violent force is kind of pretty much contemplated by that. It seems like violent force is somewhat contemplated by that transaction. All right. Okay. I guess I don't understand attempted murder, or at least hiring a hitman. Hiring a hitman is not an act of force. Okay.
That's a function of the categorical approach, right? It's not, you're not talking about your client, you're talking about the statute.
That's correct, Your Honor. Congress had a very specific theory when it wrote the Elements Clause. It was not aiming for all or even the most serious offenses. It was aiming for a certain type of offense actively using violent physical force against another, the character of which changes when you add a gun to the mix.
But, counsel, we also said in Castleman and Stokeling that we look at the nature of the crime, and that influences the scope of the interpretation. And so if interpreting the statute...
The idea is that since the murder statute doesn't require violence, then all murder is not a crime of violence. The murder statute doesn't require violence? How's that even possible? It's like saying that you can do a murder without committing an assault. How? What strange hypothetical is this where you can do a murder? How is a murder statute not require violence? I'm confused. Yeah. I mean, assuming it's action. If we're back to omission, then I understand. And then we're just back to the distinction between an omission and an action. So if your argument to me is, oh, it could be an omission, then I'm like, oh, okay. And then in that scenario, it's not an act of violence. But now I just have to prove whether you're committing a thing or failing to commit a thing. So Was my theory of the crime, is it because we don't know from the conviction inherently which one it was? Is that the idea? Is this like a really sort of hyper-technical thing? So is the idea that from the pure result of the conviction, we don't know whether or not it was an act or failure to act, because either way it would have been a conviction under the statute, and so we don't know from the mere fact of the conviction which one it was? Is that the idea? And so because the statute involves both the possibility of act and the possibility of omission, and I just say, okay, you're guilty of second-degree murder. But here it's hiring a hitman. So what's the hypothetical omission now? So if the idea was I'm convicting you of murder of the second degree, and so I just have a guy before me, and this guy's been convicted of murder in the second degree. It's like I don't know from the mere fact of that whether or not he committed an act or failure to act, because failure to act could be the thing. And so I don't know from the mere fact of the conviction which one it was. It's like, okay, so that maybe. All right, but if it's hiring a hitman, like, don't I know that violence is required in that? It's implicit. How is hiring a hitman not implicitly violent? Am I off my rocker, or am I just not seeing it? How does hiring a hitman not implicitly have an element of violence in it? How's that not implicit? Because he doesn't commit the violence? Yeah, if that case, I just say bullshit. But it's not failure to act. It's not failure to act. What scenario is this? How would you even get into a scenario where it's your failure to act that caused the hitman to be hired? That is the strangest hiring a hitman I've ever heard of in my life. I have a duty to act, and my failure to act is what caused the hitman to be hired. How does that make any sense? What? Categorical approach? But it's categorical. That's my thing. It is categorical. It is categorical. It must be true. How do you hire a hitman by omission? How do you hire either a hitman by omission, or how do you hire a hitman without it being an act of violence? How are either of those things possible? How do you hire a hitman by omission, or how does the hitman not imply violence? How is it not categorical that it must include violence? How is that not categorical? I'm an old man ranting at clouds.
A certain way, or interpreting violent force a certain way, would have the effect of excluding and making the statute virtually inapplicable to most of the statutes in the states. Robbery or domestic violence, or so here, I mean murder.
Yeah, so a few points on that. First of all, Stokeling was an instance where the court was interpreting a common law term of art, force, that made an appearance both in the federal statute and in the state statute. So it made a lot of sense to look at the states to see how they use that.
Okay, if you want to apply the categorical approach to the crime rather than the act, then okay, fine. So we can get off the hypo. So if you want to apply the categorical approach, which you should, if you're going to do this, then you wouldn't be concerned about the particular act. Okay, that's fine. So we don't have to concern ourselves with this particular case, because we're going to think about it categorically. I'm happy with that, because I'm a categorical kind of thinker. I like categorical thinking. I think it tends to be a good way of doing things. So it's like, okay, we want to think about this categorically. Fine. So let's not worry about this particular case. Let's just worry about all possible cases. Let's worry about all possible cases. All right. You've been convicted of hiring a hitman for murder. Okay, how is that not categorically violence? How is it possible that, one, it can be done by omission, or two, not violent? How is either of those things possible? How is it not categorical that it must be an act and it must be an act of violence? How is that not categorical? How is that not absolutely true? The violence is not done by the hitman, but by the guy hiring it. Yeah, but that doesn't matter. It shouldn't matter because, like, then I'm just back to standard agency law. Like, I'm just back to standard. Okay, I'm back to like, okay, the principal is responsible for all acts of the agent. Plus, it's an explicit instruction to the agent. It's please go on my behalf and commit the violence for me. Please go on my behalf and do the violent thing. Well, you know, standard agency law. The principal is responsible for the acts of the agents. So if the agent's responsible, the principal's responsible. Like, you know, so the principal did it because the principal's the one who commanded it. So he was convicted of attempted second-degree murder, not of hiring a hitman. Oh, okay. Well, then maybe I misunderstood misunderstood the question. Oh, okay. Hold on. Let me go back. Attempted murder and aid of racketeering. So he wasn't found guilty of hiring a hitman. He was found guilty of attempted murder and aid of racketeering. Okay. Okay. Let's see. He was found guilty of A5. Let's take a look. Whoever, as consideration for the receipt of, as consideration for a promise of anything of pecuniary value from an enterprise engaged in racketeering, or for the purpose of gaining entry or maintaining increasing position in enterprise, murders, kidnaps, maims, assaults, commits assault resulting in bodily injury, or attempts to commit a crime of violence against any individual in violation of laws of any state or United States, if he's guilty of attempted murder, well, I'm not even sure omissions qualifies in this category. Like, can you be guilty by an omission in this? Whoever, as consideration of receipt of, or as consideration for a promise or agree to pay anything of pecuniary value from an enterprise engaged in racketeering, or for the purpose of gaining entry to or for maintaining increasing position, murders, kidnaps, maims, assaults, commits assault resulting in serious bodily injury, or threatens to commit a crime. Yeah, I'm not sure that you can be found guilty of that by an omission. I'm not sure an omission is contemplated by that language. So I'm not quite sure how your failure to act can make you guilty of this particular statute. The issue is the law only requires the state to prove the attempt at murder. Well, okay, so I think I'm just very confused now. I think I'm just very confused now. I feel like I've failed you, chat. I feel like I've failed you. There is something that's going on here that might turn on some sort of like very technical aspect of some sort of state law issue. And I feel like I'm not completely understanding the issue. And I'm off. in my analysis. I don't understand the problem.
Beyond that, the court is not convinced, it doesn't engage in a sort of nose-counting exercise. And even with respect to states that have murder statutes, it's not as if they're all...
It did not require the jury to explicitly find that he attempted violence. So if there's ways that attempted murder can occur without violence. Attempted murder? Can attempted murder occur without violence? Okay. Is it possible to commit attempted murder without violence? It may be. This would be a very strange scenario, but is it possible? Is it possible to commit attempted murder without violence? I guess it might be possible. I guess it might be there might be some scenario, but it's got to be thin. But okay.
All going to be in or all...
So you think there would still be in many states many murder convictions that would still qualify? It just seems, I mean, you can understand why stepping back, which is I think Justice Alito's point to, you know, those observing the argument in the courtroom, to say that murder isn't a crime of violence and will rarely trigger the provision here seems a little counterintuitive.
I understand that, because if you were to ask someone, is murder a crime of violence, they would say, of course, in the vast majority of instances, the way you commit murder is going to be violence, which makes it a perfect fit for the residual clause. The idea that under the residual clause...
But you think that Congress thought it was only covered by the residual clause and that it wasn't an elements offense, murder?
So I think that if Congress wanted us to do this sort of as a category assessment, it would have enumerated murder the way it did for some other offenses. Instead, what it said is, we want you to look at whether their element of the offense involves the use of violent physical force. Because again, if you add a gun to that sort of offense, so robbery offense, for instance, robbery is obviously dangerous enough, but when you add a gun to the mix, the danger goes up exponentially. It changes the character. Same is not true for an omission offense. Obviously, omission offenses can be horrible and can be punished severely, but you don't change anything about it when you add a gun. And so it's not the sort of armed career criminal behavior that Congress was aimed at.
And didn't Congress really home in on this? I mean, you talk about at least some of the legislative history for the Criminal Code Reform Act in 1981. And I was struck by a particular example in a report that Congress, the Senate report, where the report talks about a dam operator who threatens to refuse to open the floodgates during a flood and thereby places residents' lives in jeopardy. And the report says, quote, assuming the operator had some legal duty to act, his threat would be to engage in unlawful conduct dangerous to human life, which is not a crime of violence, since he did not use or threaten to use physical force. So it seems as though we had examples in the record that Congress was aware of omission and made pretty clear that when you don't act, you're not threatening to use physical force in the way that they intended.
That's correct. It's remarkably specific. And I understand that not all members of the court are taken with legislative history, but we can rely on it just as a sort of contemporaneous use of the relevant terms in context. One of the most remarkable things about the government's brief is that they haven't identified a single instance, and they looked high and low both in published opinions and also in news articles. Every single one of their examples was someone who had used something actively, not passively, not the sort of passive benefit theory. They were described as, for instance, NASA using the moon's gravitational field by shooting a rocket up into space and then aiming their satellite at the right point to make contact with the moon's gravitational field. This idea that you can use something just by passively benefiting from it, the government wasn't able to identify a single real-world instance of it, in contrast to the one that you've just identified, Your Honor.
How about I used the rain as an excuse to stay indoors?
So I think, first of all, you can use the rain in that sort of conceptual sense. It's very different from using something in a physical sense, like physical force. And even in that instance, you don't have the against another or against the person or property of another phrase, which also is a sort of physical phrase. Again, in the government's brief, they don't identify any instance other than one that they make up themselves that uses use and against another in combination. And the example they come up with is he used the victim's disease against her. But there, it's against her interests, not against her person. So again, the government presumably spent a lot of time trying to come up with this passive benefit sense of use in combination with against another. And if this is all that they can come up with, I think we can conclude it's not a normal way of speaking.
In most of our cases where we've talked about what use is doing in this phrase, we've talked about it as a requirement of mens rea. In other words, to use physical force means to have some understanding in your head of what that physical force is supposed to achieve.
Right.
So we haven't suggested that it really adds to the physical force language with respect to the actus reus.
So I think that's correct, but let me just sort of trace it through, and I think it actually comes out where we're asking you to. So the first appearance of interpreting use in 924C is in Bailey, where the word use is in combination with a firearm in C1. And the court looks at dictionary definitions and say they imply action and implementation. And it adopts an active employment sense of the word use. And it rejects the government's argument that you can use a firearm even if it's just stashed in the closet because you derive some benefit from it. So it's an actus reus interpretation of the word use. Then that was ported over to an elements clause in Leocal and then again in Borden. And you're right that Leocal and Borden were both about the mental state, but they adopted wholesale the active employment sense of use. And that active employment sense came from what Bailey said was the ordinary meaning of the term. So unless somehow they ported over just the mental state part of active employment, even though mental state wasn't at issue in Bailey, then I think you bring the whole thing along with it.
If we adopt the government's view of use as not being personally employing some instrument, but allowing the laws of physics to take their course. What was the point of us deciding that this statute is different than the domestic violence situation?
Sure.
Aren't we just back to that?
Yeah,
because anybody who wishes to use the laws of nature to harm another is convictable. And I mean, this is just a statutory enhancement. Your client's going to spend a lot of years in jail. This is just how many more.
That's
right?
Correct. Yes. So, and I think there are some
and we don't really care about your client here, do we?
Well, I can't.
We're trying to get the law right.
I wouldn't presume to speak for you, obviously. Yeah. We do care about the extra 60 months that he would spend in prison.
That's what we're talking about. How many years is he already spending?
So regardless of the, separate and apart from the C3B conviction, it's 240 months.
All right. Yeah. Back to my question.
Yes. So the domestic violence statute, very briefly,
5
had a very
years,
different function, which was to close a loophole that made it lawful for certain
25
misdemeanor offenders to possess a gun. And the court was concerned that if it read the clause narrowly, it would render that provision inoperative in a number of states. Here, there's no dispute that obviously murder is going to stay very illegal will everywhere, and our reading would not render the elements clause inoperative in any state.
Thank you, counsel. Justice Thomas?
So are you really talking about your oh, that's okay. Are you really talking about your client? And we make this distinction between action and omission. Are we talking, because we're in the world of theory now, we're not really talking about what your client did, as Justice Alito alluded?
That's right. We're here as a consequence of invalidation of the residual
So
clause.
would your case be different if we did not use the categorical approach?
I suppose it would, but although this court has considered abandoning the categorical approach for the residual clause, and at least one justice has for the enumerated offenses, I'm not aware that any justice has considered it for the elements clause, because it requires as an element the use of violent physical force.
But I mean, I think it's fair to say, though, that we are discussing something that bears no factual relationship to your case.
So I accept that, Your Honor, and would respectfully suggest you essentially take the position you did in Borden, which was to say whatever it is, criticism about the categorical approach, but then to give the elements clause its natural meaning.
Justice Alito? Justice Jackson? Justice Barrett? Thank you, counsel. Mr. Fagan?
Thank you, Mr. Chief Justice, and may it please the Court. It's hard to believe that we're actually here debating whether murder is a crime of violence, as I think petitioner just acknowledged.
I mean, yeah. It's like, yeah, it's like some sort of conceit. I don't know what the right way to phrase this is, but it's something only like a really smart person could do. You know, like no one who is dumb or even of average or even high intelligence could ever come to the conclusion that murder is not a crime of violence. It's only someone who is really, really smart or something who could possibly tie themselves up into enough knots that we're having this stupid discussion.
This is one case where the law already tracks common sense. Castleman tells us that internal force, like a disease, can be physical force. It also tells us that physical injury must result from physical force, and the Borden plurality recognizes that someone uses force against the person of another when he makes force his instrument to cause that person harm through force. I used force twice there, but I think you get the point. And there's really no basis in law or logic to draw a distinction between the person who gently sprinkles poison in the cup and the person who, hating the victim, just withholds the antidote. By urging that distinction, petitioner is asking this court to discard literally 2 millennia of common law that treat acts of omission just like other acts. He's asking this court to cut out any number of canonically violent murder, robbery, and assault offenses out of 924C, the definition of violent felony under the Armed Career Criminal Act, and the definition of misdemeanor crime of domestic violence as relevant to 922G9. And he would make all 3 of those statutes, he's asking this court to make all 3 of those statutes turn on distinctions so arbitrary, unprecedented, and bizarre that it would make application of those statutes, again, Your Honor, I use this word with respect, truly absurd. I would like to address a couple of his points, but if the court has questions, I realize my light just flashed.
Mr. Fagan, we normally think of force as coming from the perpetrator, not from some outside force, like gravity or some internal disease. So how do we get from where you are to where he is? I think his argument actually does make does have a common sense value to it.
Well, Your Honor, I think as Castleman demonstrates, we know that whatever force causes death can be an internal force. It can be the action of whatever action within the body is induced by poison. We also know from Castleman one of the examples it uses is a disease. So the actual death-causing force can be a purely internal force. If I know you have a weak heart and I frighten you and you die, your body is attacking itself. That's also true if you intentionally and tortuously starve a child. That's the starvation causes the body to attack itself. It starts eating itself away because it has no other source of nourishment. If you're asking me about whether that force has to be in some way, I think the words petitioner uses in the brief are unleashed or channeled in some way by the defendant. I think that's somewhat of a gerrymandered requirement. He's trying to do it to catch things like, the wind catches your sail, or the example in our brief where you're involuntarily placed on a raft. You see which way the current is going, and you use the current to get you to shore without doing anything. But that channeling requirement is equally satisfied in an omission case, where you can stop it. Force is going to occur. You can stop it. You should stop it, and you don't stop it because not stopping it accomplishes your purpose.
Mr. Fagan, on that score, if we're going to talk about common sense, and that's a good place to start sometimes, your view, I think, would capture the Good Samaritan example as well and make that subject to an additional enhancement under ACCA, right?
I don't think that's necessarily true, Your Honor.
Why not? Just to set the table again, we have somebody, a passerby on the street, who doesn't like little old ladies and intentionally allows someone to fall into and die. And the physical force, your view is gravity's good enough. I don't have to push her. And now that would depart from the common law where there's normally a duty, but pre-existing duty. But here we have a Good Samaritan statute. So that is an ACCA offense in the government's view, and why wouldn't that defy common sense?
Not necessarily, Your Honor. Let me explain why. I'll take just 1 second to unpack this. It turns on what it turns on how you interpret use of physical force against the person or property of another.
Yeah, but
and
you use rivers and currents, and what's wrong with gravity?
Gravity is fine. It's the problem of your postulating that some state has some kind of aberrant duty.
Oh, no, it's not aberrant. Some states do, and many in Europe have a good Samaritan laws that impose affirmative duties that didn't exist at common law.
We think that in order to use physical force against the person of another, there has to be, number one, a deliberate choice. That's
sure, I got that.
That's what the Borden plurality tells us. And two, the common definitions of use, like avail oneself of, we do think have an element of causation in there. And
yeah, no, there's no doubt that my failure to act caused this person's death. I've got causation and I have intention. I have mens rea. Now, I understand that when there's a common law duty, our intuition is that that's really bad. When a parent doesn't feed a child, when a doctor doesn't care for a patient, that's problematical. I'm testing how far, and I don't see what line you would draw between that and the Good Samaritan statute, which, again, many states have.
So causation includes both cause and fact, which we have here, and proximate cause. And I think the proximate cause inquiry...
Let's say I have that box checked, too.
Well, Your Honor, I think where we part ways is I don't think I necessarily think you have that box checked in your example, and here's why. The proximate cause that's built into the statute here, I think, can be informed by the common law of duty.
No. Again, I have a statute that's a Good Samaritan statute that imposes a higher duty on ordinary people to be Good Samaritans. And so it creates a proximate cause. test. It's different from a common law test.
So
you're just resisting the hypothetical, and I can understand why. Because the consequence of your interpretation has its own common sense problem. It would capture all omissions cases wherever the duty comes from.
With respect, Your Honor, if I could just explain, I don't think I'm resisting the hypothetical. I think I'm just explaining that as we normally do in interpreting these kinds of statutes with the categorical approach, there is some concept of generic federal law, and here what federal law might mean by use, its concept of proximate cause, would be informed by the common law scope of duties as of 1984.
Where does that come from? I didn't see that anywhere in your brief. That's new here at the lectern. Where does that come from?
Well, Your Honor, I think that's just how we've been interpreting these statutes. It's always a question of federal law.
The term use depends upon common law duties in 1984.
Well, Your Honor, we think use.
Has any court ever said that?
Proximate cause.
Yeah.
It hasn't, Your Honor, it hasn't come up because until the Third Circuit.
Right, but it will after this case.
Mr. Fagan, can I ask you, just piggybacking on what Justice Gorsuch is saying, I guess I'm just trying to understand the government's position on what it means to use physical force against the person of another in an omission case. So let's take this hypothetical. Say you have a lifeguard and she has a duty of care to rescue children in the pool. A kid who she hates, gets into the pool entirely of their own volition. Is it your position that she uses physical force against this kid if she doesn't jump into the water when she sees him drowning?
Yes.
That's what I say to that. I blow a raspberry at that one. It's like, I don't know, ma'am. I don't think I agree with that. I don't think I agree with that hypothetical.
Okay, so how can that possibly be? I mean, you're saying she uses physical force.
Oh my God, are me and Justice Jackson on the same side of this issue? Maybe I need to rethink this over again. Holy shit.
That means no action but an intention that this victim succumb to a harm that she didn't put into place, that she had really nothing to do with, but she sees it happening?
So, Your Honor, she is using physical force against the person of another because, again, she could stop it, she is legally required to stop it, and she doesn't stop it because she wants the victim to die. To use a dictionary definition...
So it's only her mental state that is doing the work of her using physical force?
No, Your Honor, it's the combination of those things. Under just a plain dictionary definition of use, she has availed herself of the force, she has had enjoyment of the force, she's made the force her instrument to accomplish her purpose.
All right, let me ask you about the other parts of the statute, the attempt and threaten. Same situation. How does it work in an omission case for this lifeguard to threaten the use of physical force against this kid? Is it because she says something to him that would make it a threat? Like, I don't understand how omission works with respect to the rest of the statute.
Well, Your Honor, if I could depart from the lifeguard example where it might be...
No, I want the lifeguard example.
You want an example?
I want to ask you, in the lifeguard example, if she says...
Yeah, that's not really a place you want to be as an advocate. That's almost invariably the wrong answer as an advocate. Okay, I want to ask you about a lifeguard and what might be true. Well, I'd like to move away from the lifeguard example. Ooh, no. That's the wrong answer. That's the wrong answer.
Hey, kid.
Lifeguards under no duty to save everyone? Yes, they are. They're exactly why they're hired. A lifeguard does have a duty. Yeah, a lifeguard does have a duty. That's the whole reason they were hired in the first place. Yeah, they do have the obligation. Let's stick with the hypo, people, though. Let's not move away from the hypo.
If you get into the water but can't swim or start to drown, I'm not coming to get you. Is that a threat of use of physical force in your view, or how else would you accomplish the threat part of this?
Well, 2 points, Your Honor. Number one, I think if that were generally considered a threat for purposes of the substantive statute that the person also has to violate under state or federal law, then perhaps that would be the threatened use of force. But it's easy to see threatened use of force in omission cases and other examples. Suppose you're the caretaker for an old sickly man and you tell him, look, I'm not going to give you your medicine today, and you're going to die unless you give me the combination to that safe over there where you keep all your gold bars. That is threatening an omission. I think everyone would consider that threatening an omission, and it's.
But is it a crime of violence? I mean, this was the point that Justice Gorsuch, I thought, was making before, that you may have culpable conduct under the law, but what we're looking for the purpose of this enhancement is violent conduct, violent criminal conduct. And I guess what I'm worried about is the government's interpretation that has, lifeguards and caregivers and people who very intentionally and perhaps even criminally withhold their duties actually being put in the bucket of violence even though they don't act.
Well, Your Honor, if you look at page 550 of the Court's decision in Stokeling, you'll see one dictionary definition of violence that defines it in terms of the causation of physical harm. And in these cases, let's not lose sight of it. Someone is using harm.
But they're not using, Mr. Fagan. That's my problem is I don't understand how you get use to inaction, how you get use out of inaction.
So, Your Honor, maybe a few examples.
Justice Jackson and I appear to be on the same side of this issue. So that's the surprising part of my day. Justice Jackson is equally incredulous to this idea that inaction can be use and doesn't buy this. Justice Jackson and I apparently agree on this. It's a strange day for uncivil, but that's apparently where we're at. Moving on.
He accuses us of having no examples. I think if you look at our brief, you'll see a number of them. But let me give you an example that comes basically straight from one of this Court's own opinions, which is, let's take a look at the Borden plurality again. Borden plurality has an example of use of physical force against the person of another when someone is driving a car, sees someone come in front of them, and keeps, in the Court's words, plurality's words, plowing ahead and hits them.
Action. They're moving.
Well,
right?
Your Honor, this is all just a game of, I think this is what one might describe as just sort of a terminological word game.
Oh, fucking bullshit. Oh, fuck you. Oh, it's just a word game? First of all, we're lawyers. What the fuck do you think we're doing here? This is just semantics argument. No fucking shit, it's just semantics. What the fuck do you think lawyers do for a living? That's our goddamn job. What do you think we do here? Holy shit.
To answer these questions, Mr. Fagan, are you thinking about the use of physical force as an ordinary meaning kind of question, or are you saying it has a specialized legal meaning?
I think it's an ordinary meaning that's informed by the common law. So, Your Honor, to the ordinary meaning point, on the Borden plurality example, I could easily describe that conduct as simply omitting to hit the brakes or omitting to turn the steering wheel.
And then we'd say you're playing word games. Because I think when you push your foot on the accelerator and drive your car into somebody, that's not really such a hard case.
No fuck. Again, duh, right? If you're pushing the pedal, that sounds like an action. Have I suddenly become a left-leaning member of the court when I wasn't paying attention? Because it seems like Justice Kagan and Justice Jackson are speaking my language here. Seems like they're speaking my language here. What? Okay.
But some of these are hard cases, like the lifeguard example, where we would say, the lifeguard is just sitting there. And this is not like what a normal person would think of as a use of physical force. So it's almost as though we have to pick our absurdity. You started with one absurdity. We would say that murder is not a crime of violence. That seems pretty absurd. But here's another absurdity. The lifeguard is just sitting up there watching somebody is using physical force. That seems pretty weird, too.
So, Your Honor, I think your two questions, as Your Honor probably recognizes, really pair together here. And the reason that we have 2 millennia of law that don't draw this distinction is precisely because it is a word game. If you look at, for example, the Hall treatise that we cite, that's from 1960, but still substantially predates the ACCA, or you even want to go further back and you look at the 1875 Wharton treatise, you'll see that the Wharton treatise, for example, in section 72 says even sleeping can be an affirmative act, and it can lead to liability when there's something you're supposed to be doing, but you're not doing it.
I have no problem with that either. That's correct. If you choose to sleep, if that's a choice, and you're not supposed to be doing that, if the lifeguard takes a nap in the middle of their shift, and it's not that, they passed out. It's not that, they got heat stroke. It's I like nap time. Nap time sounds good. Let me set the alarm for 15 minutes while I drown out the sounds of the drowning. Right? Then yeah, that's an action too. I mean, whether or not that's an act of violence is a whole nother set of problems, but okay. Yeah.
And the common law sources that we cite, both Hall and Territory against Manton, which is an 1888 case, have no trouble describing those kinds of omission cases as involving the use of force.
Counsel, I like to get back to the lifeguard also. You say the force she was using the force of gravity. And was she using it before the child jumped in the pool?
I know, Your Honor. And
so she did something that suddenly gravity was there?
Well, Your Honor, what happened, first of all, I don't think the force here is the gravity. I think the force is whatever happens within the body you can conceive of it in a number of ways. It could be the force of the water. It could be the gravity. It could be as...
What is the force of the water?
Something has gone catastrophically wrong. Something has gone catastrophically wrong. We're asking, what is the force of the water at the Supreme Court? Are we doing a Terence McKenna lecture now? What are we doing over here? What the hell is water? Okay.
I don't know if I guess the pool is probably not deep enough for her to get crushed in it, but the gravity is dragging her down in the pool. There's an internal process going on in her body whereby her life is sucked away from her. I apologize, I'm not a doctor. I couldn't quite tell you what happens with asphyxiation, but the body's going to be attacking itself there, gasping for air, eventually die.
It's the same thing Justice Kagan said. The lifeguard's not doing anything.
Well, Your Honor, to your specific point, I could easily reframe it as the lifeguard withholding from the lifeguard's duty to rescue the child. And if you think of I think this is easier to see, and I'll translate the lifeguard example in a second, but easier to see in the Borden car plowing ahead example. If I just...
The car plowing ahead is different than the lifeguard doing nothing.
Well, I don't think, okay, Your Honor, I think the lifeguard is using the force there because the lifeguard is using some physical force that causes the victim's death.
I hate this answer. The lifeguard is using physical force? No, they're not. They very well have a duty to act, but they're not acting. They're not using force. That's ridiculous. They have a duty to act, and their failure to act might make them liable for murder, but they're not using force. I mean, okay.
And the lifeguard wants the victim to die. The lifeguard
wants
the victim,
all that's beside the point. Your submission is that somebody who's just sitting there is using force, the force of gravity,
I mean,
and the force of the water.
Under a plain definition, he's taking advantage of the force, he is availing himself of the force, he's enjoying the force, he's making the force his instrument.
But he's not doing anything.
Mr. Fagan, if I might just follow up on this. Is there any death that's intended and caused by somebody doing nothing, like our lifeguard, that wouldn't involve the use of violent physical force, because every death is going to be affected by gravity or water, and the body will fight itself in your terms? I mean, that's how death occurs, I guess, in the government's view.
Your Honor, to answer
what death wouldn't qualify?
So to answer your specific question, I don't think every death involves someone using physical force against the lifeguard another.
Do it.
But
I feel like dumber by this Supreme Court argument. I feel dumber. This may be the dumbest Supreme Court argument I've heard in a hot minute. This feels pretty dumb.
I do think that every death does involve physical force. The physical
every
force
death involves physical force, and why wouldn't it all be violent? Because it's all extremely unpleasant.
We do think every death involves physical force and violent physical force within the meaning of Curtis Johnson.
Okay, all right,
Not all of them are going to satisfy this statute.
Someone said it earlier. Someone said it earlier in chat. This entire discussion feels like a bad turn from a freshman philosophy course. This entire discussion feels like we're having a freshman philosophy course, and things have gone off the rails, and now we're in stupid la la land. It feels like we're on the stupid end of a bad entry level philosophy course somewhere. How is this real life that we're doing this?
They're all violent
not
physical
all of
force,
them are
though.
going. Yes, Your Honor.
Okay.
Because
all right. I got another question for you. I got it.
Can I add?
Sure.
I'm sorry. I just wanted to add the point that the physical force requirement of the statute is not to carve out things like murder and physical harm. It's to carve out like property crimes, fraud, that sort of thing.
But all murders are, by definition, the use of violent physical force. I think it has to be.
Subject to the proximate cause caveat I was discussing with you earlier, Justice Gorsuch.
Okay.
Yes.
Okay.
And the mens rea.
It's going to be right. And the mens rea, of course, that I also mentioned at that time.
But, all right, it's kind of a little strange to think that Congress meant by this, if we want to talk about common sense, that every death is encompassed, so long as I can meet mens rea and causation. But put that aside. I really think you're struggling to, if I'm honest with you, to try and defend a position that just has nothing to do with this case, right? We've got a defendant over here who ordered a hit job. I mean, that's what the common sense on your side.
And handed them the gun.
And handed them a gun in a paper bag and the whole 9 yards. It's like out of a movie.
Yeah, right about now, this guy lost at the level below, right? Yeah, he lost at the level below. The Court of Appeals told him to go stuff it, right? The Court of Appeals told the criminal to go stuff it and shove it up his ass, right? Because it's Delligatti versus United States. Delligатti's the one appealing. So right about now, I think the Supreme Court is looking for that dismissed as improvidently granted button. Where is my dig stamp? Where is my dig stamp? This discussion is too stupid. I can't believe the U.S. Supreme Court is having this argument. Where's my dig stamp? We're going to pretend the whole thing never happened. We're off in this esoteric discussion about whether it's a crime of violence or not a crime of violence. Meanwhile, we've got a guy here ordering a hit who's literally handing the gun in a paper bag to the guy. Okay, this is not the case to be having this discussion. This is 100% not the case to be having this discussion. Where is my dig stamp? Dig, dig, dig. We don't know what you're talking about. The U.S. Supreme Court's never heard a case called Delligatti versus the United States. Never happened. What are you talking about? You're talking madness.
And here we are talking about lifeguards and omissions. And it makes me wonder whether, again, as I asked your friend on the other side, anybody considered whether this statute might be divisible, because traditionally, murder statutes encompass two very distinct things: acts, ordering the hit job, and omissions where there is a pre-existing duty of care. Very different. Is that resonate to you at all? It might help you.
Yeah, Your Honor, I think we might make divisibility arguments with respect to some statutes, perhaps including this one, if the court were to rule against us. Obviously, we won in the Second Circuit, and we didn't make a divisibility argument because we were already...
Well, if that's the case, maybe we go back to Justice Kavanaugh's question from the last case. Why wouldn't we remand this to ask that we resolve that first before we start talking about lifeguards and every murder being encompassed within this?
If I were on the Court of Appeals and the U.S. Supreme Court sent this back to me on remand with discussion to talk about lifeguards, can I say no? I don't want to talk about that, Supreme Court. I'd like to talk about things that make sense. I don't really want to talk about that. Can I say no?
Well, Your Honor, I think this is going to come up in any number of cases, whether or not the court resolves it here. And because, as we point out in our brief, 35 states by statute include omission liability, and one common way to do that is just to define the word act to include omissions. That's the way New York does it.
Omissions plus duty of care is what they do. And so, again, if you won here, you'd have a great precedent that maybe that some of the others would be divisible too. I would have thought that would have been useful to you.
Well, Your Honor, we did not make that argument below. It's a state law argument that we don't think is appropriately made in this court, and we do
I agree with that.
What would a divisibility argument as to this statute look like, if I can ask?
I think we would probably be relying on cases, and New York has some, where because omission liability, as Justice Gorsuch just pointed out, requires a duty as well. There are cases where the jury instructions, for example, were found deficient because they didn't specifically allege the duty. But there are cases, and there are a couple of examples of them in the briefs, where something like horrific child neglect and also beating a child, they're kind of charged together. So I think the outcome of that would be a little bit in doubt. And that's actually the only reason why we've said that all of the statutes listed in our appendix are just at risk. It's the same thing the court said in Voisin. They're at risk because we're not quite sure how the divisibility analysis is going to shake out. But there's no question that we've already lost in the Third Circuit. There's no question that that's going to affect charges under the hate crime statute in that circuit. It's going, and we think if the court were to rule against us, it would affect charges in the hate crime statute. In other cases, the Buffalo supermarket shooter has raised this very argument and preserved it. And if we lose it here, then the hate crime statute is not a crime of violence, killing somebody because you are biased against their race, because it could possibly be committed by the conduct of being a daycare worker and realizing that there's a bomb in the building and deciding you're only going to save the children of one race.
So the hypotheticals have gotten too stupid. The hypotheticals have gotten too stupid. Abandon ship, people. Abandon ship. The hypotheticals have gotten too stupid. I'll tell you what. If that case ever happens, we'll talk. Until then, I can't be bothered. This is just too dumb.
Are you fighting the categorical approach? Isn't that the root of your problem? And I guess, I mean, the divisibility argument has a lot going for it, but how does it fit with the categorical approach?
Your Honor, not every statute is going to be divisible by act versus omission. It's very common to define act as, define it by omission. That's the model penal code definition in section 1.137. But as to fighting the categorical approach, we had that fight a few years ago and we lost, so I am no longer fighting the categorical approach.
Well, I'm just wondering if you're trying to get in the back door.
No, Your Honor. The point I'm making is I think that approaching this with some sort of degree of common sense that is here informed by 2 millennia of common law, and Forcine looked at the common law.
This guy isn't allowed to say the phrase 2 millennia anymore. This guy is not allowed to say the phrase 2 millennia anymore. Yeah.
To a certain extent, in interpreting what the term use meant.
The other side says that the common sense is really captured by the residual clause.
Your Honor, let me make several points about that.
And let me just finish. Okay. And the residual clause, of course, in Johnson and Davis was declared unconstitutional, and that the other side says what you're. And by the way, it was pointed out that would lead to absurdities, and here we are, and that you're trying to jam cases that would have naturally fit under the residual clause into the other clause. So that's what the other side is suggesting.
If I could have a second, several points on that. Number one, I think he's trying to have it both ways. He's arguing that Congress wouldn't have wanted this to be a crime of violence at all, and he's relying on this residual clause argument. As to the residual clause argument, this isn't a case about potential risks, which is what the residual clause covers. This is a case where we know somebody dies. I think the court has not relied on the residual clause in other cases where it might have equally been applicable under the kind of logic you're suggesting, Justice Kavanaugh, like Stokeling. I think that's because everyone recognizes the elements clause has its own specific function. I'd also point you not just to 924C3's residual clause, but to the Armed Career Criminal Act's residual clause, which is worded a little bit differently, although no one thinks it affects the scope of the elements clause. It requires a serious potential risk of physical injury. I don't know who could think that that's the way you're capturing murder. It doesn't have a serious potential risk of physical injury. Somebody gets harmed.
Yes,
and then
Mr.
finally.
What? I'd also point out to you not just 924C3's residual clause, but also to the Armed Career Criminal Act residual clause, which is worded a bit differently, although no one thinks it affects the scope of the elements clause. It requires a serious potential risk of physical injury. I don't know who could think that that's the way you're capturing murder. It doesn't have a serious potential risk of physical injury. Someone gets harmed. Doesn't that just mean the risk is 100%? And that sounds like a serious potential risk to me. I mean, you know, I think there's probably a very serious potential risk of physical injury in a murder case. I think that if there's going to be a murder, there's a very, very significant serious potential risk of physical injury. What the hell are you talking about? Very, very high, extremely high.
Oh, go ahead.
I'm sorry.
Go ahead.
And then finally,
Sorry.
I just want to point out that Section 922G9's, the definition doesn't appear there. That's in Section 92133A. The definition of misdemeanor crime of domestic violence doesn't even have a residual clause. And if you look at the appendix we submitted in V.I.C., most of the assault statutes the court was worried about there are defined in terms of causation of harm or causation of offensive touching. I thank you for your indulgence, Justice Jackson.
Yes, no, Mr. Fagan, I appreciate that somebody died here and that we would ordinarily think of murder in that situation. But it's clear that the language of this provision of the statute is not focused on the outcome or the effect. And I think the common sense reading of this that cuts against you is the fact that physical force has a common sense meaning, use has a common sense meaning, and that it suggests that the defendant has to act, that they have to do something. And so Justice Gorsuch's point is about
which, under this fact pattern, I still don't know how that isn't true. I mean, he gave the murder weapon to the guy. That's an act. Sounds, sounds a little murderous to me, man.
Divisibility is kind of my thought, which is at the beginning of this, it seems like we have a bifurcation of the Congress's view that you have action by a defendant and you have omission in a different column, and we're sort of in the realm of action. So I guess my question is, how could Congress have possibly written the words use, attempted use, or threatened use of physical force and meant...
David, even if you're right, and I'm not saying you're wrong, David, that we wouldn't evaluate it based on the fact pattern, but based on the elements of the crime because we're doing it categorically. It's like, even if you're right, and I'm not saying you're wrong, I'm still back to this is a bad vehicle for this discussion. This is a bad vehicle for this discussion. It's like, give me a case that, that isn't like so obviously... that isn't so obvious. Give me the lifeguard case. Let me know when that really happens. Give me that case. So I'm not saying you're wrong for ignoring the fact pattern and just like going to the actual elements of the crime and look at this categorically. I'm saying that this is a bad case, man, for this point, man. Back to dig. Can you dig it? I can dig it. I can dig it. Let's dig it. This is a bad vehicle for this discussion, man.
That the defendant doesn't have to do anything at all.
Well, Your Honor, this goes back to the common law backdrop against when, I think the easiest way to see that there's some linguistic ways to see that too.
No, I'm just looking at the text of the statute. If you're right that what Congress was trying to capture with this is a defendant, a victim dying or a person being injured bodily, Congress has said that many other places, even in this very statute, when that was the triggering thing. What I'm worried about is interpreting the words use, attempted use, and threatened use of physical force to encompass a situation in which a person is not acting. That seems completely counterintuitive. It seems like it has no bearing in the words of the statute. I've already talked with your friend on the other side about the legislative history that actually shows that Congress wasn't talking about omissions. But how do you get past this sort of conceptual concern that we're really talking about doing something here, and you're suggesting that you don't have to?
Well, Your Honor, if I could respond, I would have like three principal points in response to that. One of them is the premise of your the premise of your question was that this statute doesn't look at results. But I'd respectfully point the court to Castleman and as well as Justice Scalia's concurrence in Castleman, which both point out that where you actually have physical injury, it must have been caused by physical force.
Castleman was dealing with a different question, like how much force, what is force, is putting the poison in the drink enough to be physical force. I'm talking about a situation in which a person does nothing.
Okay, the second point I'd make, Your Honor, and I've been trying to make it this morning, and I take it as part of your question, you've kind of rejected this, but I do think it fits squarely within the dictionary definitions. Again, if my car's just rolling down a hill and I see my enemy walk in front of me and I let the car keep going and just don't do anything, I think we'd all say I used physical force. Now, maybe I got in the car and turned the key and started the car, but I certainly didn't have the intent to use physical force against the person of another. I only had it at the point I stopped doing something. And the third point I'd make, if you'll indulge me one second longer, Mr. Chief Justice, thank you, is that I don't think this would have defied common sense because, again, if you look at all the common law sources, everyone recognizes this is a word game. Do I call it withholding? Do I call it not acting when I refuse to give someone medicine? And the common law has always treated doing something other than what you're supposed to do, fiddling while Rome burns, as an affirmative act. Thank you, Mr. Chief Justice.
Thank you, counsel. Justice Thomas? Justice Sotomayor? Justice Barrett? Justice Jackson?
This argument is too dumb.
Okay, thank you.
Thank you, counsel. Rebuttal, Mr. Keenum?
Thank you, Your Honor.
This argument is too
Starting first
stupid.
with divisibility. When this court has asked whether a statute is divisible for purposes of the categorical approach, it is asking whether it is linguistically divisible, whether the text of the statute allows it to be divided into separate offenses. Sometimes there are a list of different ways of committing an offense. Sometimes they are different offenses. So you could say that burglary involves breaking into a house or a houseboat or whatever, and then the question is house a different crime than houseboat? But it has to be linguistically divisible. You don't look at, and you can look at state common law or otherwise to figure out whether those are different elements or means, but you don't look at case law generally to ask whether omissions are different offenses than not. That is what my friend is asking you to do, something this court has never done. And at minimum, if you were going to start to engage in that kind of divisibility in an entirely new realm, I would think that you'd want a case where that issue had been raised and briefed. My friend also said that essentially the only question about whether all the statutes in its appendix are out is a question about divisibility. We respectfully disagree. States can agree with the general principle, as I think all of them do, that omissions can sometimes be liable. They can accept the common law principle, but still believe that certain specific offenses cannot be committed except by affirmative acts. We have cases in our brief, in our reply brief, in, for instance, Louisiana, which accepts the general principle, but nevertheless says that felony murder cannot be committed except by an affirmative act because it is written in a way that requires a killing. And so you have a number of those statutes, even in those effective states, that wouldn't necessarily be excluded. Going to the residual clause. The residual clause is a natural home for offenses like murder, not because murder isn't always bad, but precisely because it is usually bad. In other words, the vast majority of murders are in fact violent, which is why it makes sense to fall under a clause that talks about the risk in an ordinary case that physical force against another will be used during the course of commission. It allows for these sorts of edge cases, the difficult hypotheticals that we've been talking about. The elements clause is not written that way. It requires the use of violent physical force as an element, which means in absolutely every case. And my friend does not dispute that there is no interpretive significance to the fact that the residual clause is no longer operative. Going to the word use, my friend says that use derives some meaning from the common law. This court in Bailey said use must be given its ordinary meaning, which is active employment. And you notice that when my friend started talking about using things like metabolism or the body's natural processes, he lapsed into this sort of abstract concept speak rather than talking about something physical, like physical force that you use against the person of another. Castleman examples are all indirect force. Poison, pulling the trigger of a gun, introducing a disease, by which I think the court meant if you infect someone with the Ebola virus, obviously that's an indirect use of violent physical force. But they're all taking steps to bring someone into contact with the thing, without the step you take to bring them into contact with it, there would be no harm whatsoever. So it's not a word game. Whether you describe failing to feed someone as an act of withholding or an omission, either way, you are not bringing them into contact with any force, much less violent physical force. My friend relied very heavily on the common law, as their brief does as well. He says that acts of omission are treated as other acts, and that, as a general principle, makes sense for liability. But the problem with the government's argument on that is none of those terms make their appearance in the Elements Clause, which talks about the use of violent physical force. That's the thing that has to be present in each case. And that's why, to your question, Justice Barrett, Stokeling is different because it was interpreting a common law term of art which appeared both in the federal provision and in the state provision. We're not here interpreting words act or omission. We're interpreting use of violent physical force. Finally, I want to end with a point about all these hard examples. You posed a lot of very difficult hypotheticals, both to me and my friend from the government. And the thing is, you don't have to agree with us on essentially any of them, except the pure omission scenario, where there's an octogenarian who falls into a coma and slowly expires because they are not being fed nutrition. No one would describe that as a death involving violent physical force, except for perhaps the government, which thinks that literally every death involves violent physical force. But if that, in a sort of normal scenario, is not a death involving violent physical force, it doesn't suddenly become violent physical force because there was someone who had a legal duty to provide that nutrition. It may be a very serious crime, it can be punished severely, but it does not categorically involve the use of violent physical force. Thank you.
Thank you, counsel. The case is submitted.
That case was really dumb. That case was really dumb to me. Yeah, that case seems like exceptionally dumb to me. I don't understand why we're having this discussion within the scope of this particular case. Seems like a very bad vehicle to make the point. But my view would be that you have to take action for it to be violence. And I'm perfectly happy with pulling the trigger being the act of violence. I'm perfectly happy with pulling out the medicinal dropper and dropping a couple drops of poison into the tea, that being the act of violence. I'm perfectly happy with those examples because in those examples, there's a direct causal chain to the ultimate cause of death that is obvious, foreseeable, and intended in those examples. So, like, I have no problem with, tracing the force and the violent force to that. And it seems to me that the omission is not violence, is not an act of violence. It may lead to culpability. It may lead to culpability and liability and even murder charges, but it's not itself an act of violence. And so if the idea is that he was convicted of, let's say, attempted murder, although it is pretty difficult to conjure an attempted murder that doesn't involve violence, but okay. But if the idea was he was found guilty of attempted murder, and so we don't know whether or not that involves violence, because we don't know whether it was an act or admission, at least based on the conviction we don't know. And it wasn't an element that was presented to the jury, so the jury was never asked to find that as an element, then I guess. But this is a horrible vehicle to resolve this case. Because why am I breaking my back for this guy? Why am I breaking my back for a soldier in the Genovese mob family who handed the gun in a brown paper bag to a guy and be like, go get him? Like, why am I breaking my back for this guy? So it's just a horrible, horrible vehicle for the thing. And so, in many murders there would be a gun conviction, or in many murders there would be other convictions that you could prove the violence, but maybe it's not here. Maybe this crime does not have the implicit elements of violence. So I still think that this is really dumb. I think this is a really dumb case. So I think I would dig it. I think I'd dig it and let the Court of Appeals decision stand. This seems like a really bad vehicle for this pit of stupid. So now I need to find a copy of Sarah Boone's latest missive, because I've heard that's available. So someone said Sarah Boone put a letter on the docket with her full statement, plus letters to Mr. Judge, Mr. Kanansky, instead of Judge Kanansky. So I need to find a copy of that. From Orange. Oh, from Kestrel has it? Kestrel's my hero. Oh, thank you. Aw, Kestrel's the best. Aw, Kestrel's the best. Kestrel's an okay moderator. Aww. Oh, yeah. Oh, yeah. Oh, yeah. No, we need this in my life. We definitely need this in my life. Should we do this today? When do we do this? It's 5 o'clock. It's 5 o'clock. It's Wednesday. Do we do this today? Do we do it tomorrow? If we do it tomorrow, what time do we do it tomorrow? How long is this thing? 28 pages handwritten? Awesome. This is great. Is it even legible? It's pretty legible. Let's just give a flavor. Let's give a taste of it. I don't know that I want to do it all. I definitely don't want to do it in this stream. This should be a stream unto itself, but let's just do the first paragraph of this, because this is just too good. I feel you guys, chat has been good. Chat has been good dealing with Supreme Court stupid. So since you've been good dealing with Supreme Court stupid, let's deal with some Sarah Boone stupid for a paragraph. Sarah Boone writes the following. Mr. Michael Kranick. Nice. I am enclosing, please, my complete statement to you and the world as I partially read during my sentencing hearing. By my reserving particular parts of my very true and meaningful statement, I was hoping to have been graced with your forgiveness, understanding, and consideration in any level or degree. For me, unfortunately, and regardless of when I had spoken on my behalf, or the number of, your ignorant mind was already made up. Sarah Boone is the best. She's the best. She's the greatest. Sarah Boone has done something that very few women have ever done. They just make me smile, man. Sarah Boone makes me smile every single time. She just makes me smile. I think it's just the absolute unfiltered self-belief that just is so amusing and it's almost charming. It's almost charming. She is so absolutely unabashedly full of herself. It's hard not to appreciate on some level her absolute commitment to her own ego. She is so nakedly self-serving and self-pitying. It is somehow refreshing in its honesty. She in some ways might be the most honest person I've ever met or ever heard of. She might be, in some ways, the most honest person I've ever heard of. She is so incredibly self-worshiping as to be just truly, it's a thing to behold on levels that are, I think, yet not fully appreciated. Sarah Boone is awesome. She's the greatest. She's the greatest. Yeah. Can I get her on the show? She's a little busy right now. And getting her on the show would be really difficult because it would involve an interview with a prisoner. And most prisons, I don't know what the rules on that on Florida are. I don't know what the rules on that on Florida is, but can I get an interview with Sarah Boone? Might be entertaining. That could be an interesting stream. It would be different. I'm not sure the Department of Corrections would allow for that, to be honest. But it's a thought. It is a thought. Oh, Lord. Well, I'm going to take a break for now, and I will contemplate. This is 28 pages. It's going to take a hot minute to read it. So I think I might reserve it for tomorrow so that I'll be super fresh and I'll be able to provide all the wonderful commentary that you've come to expect. I think it's going to take a hot minute to break down this glory. Oh, by the way, she plagiarized the bit about the Japanese art. She plagiarized that entire paragraph. I didn't know that, but someone pointed it out to me. Or so I saw a stream that pointed out. So where she did like Japanese, like the art of Kazuki or whatever the fuck it's called, is the art of like patching, art with gold and all that bullshit. That entire opening paragraph was just lifted almost verbatim from a book. She didn't write it. She plagiarized it. She made it her own, much like the Japanese art itself. So that's fun. So yeah. She saw a commercial promo. No. It's worse than that. It's like that entire paragraph is lifted directly from a book. So it's worse than that. She read it somewhere in her journeys. One of the many things she read in the law library apparently was this somewhat obscure reference. And yeah. Okay, let me see if I can find it. Because, hold on. Is a kind of Japanese, hold on, ceramic style, which means to repair with gold. And it is from a book. How do I search books? How do you search books? Oh, there it is. Yeah. I don't know. I know it's from a book. I'll have to find it. Oh well. Is it from this book? Hold on. No, that's not the right book. Same idea, but different verbiage. Yeah, I might have to find out the exact book, but it's definitely from a book. Anyways, I'm going to sign off for now. Ken Sukuroi. I'm going to pronounce it the way that Sarah Boone did. So when I'm reciting her letters, I am going to... how'd she pronounce it? Ken Sukuroi? Ken Sukuroi is the way she pronounced it. I don't care how it's pronounced. We're pronouncing it the Sarah Boone way, because for us that is the correct way. It is her statement. So however she pronounced it is the correct pronunciation. No, she said Kentu Sukuroi, right? Kentu Sukuroi, something like that. Kentu Sukuroi is the art, I think she said. Yeah, so that is the correct way to pronounce it for the purpose of reading her verbiage, because it's her statement, and so it must be read the way she pronounces it. Yeah. Kentu Sukuroi, I think is what she said. Oh, Lord. All right, maybe tomorrow. I think we'll do it tomorrow. Until then, my friends, I'm out. I'll talk to you later. It's been fun. Love you lots. Bye-bye. This was a very, very strange Supreme Court case. Very, very strange. I think it's going to be digged. I don't get it. It's odd.